not yet.
Oh,
Sorry,
oh.
sorry. You've been too serious. It was like, no. Everyone was just
Yeah,
suddenly, you know.
maybe it's already on.
No. We have like 3-5 minutes to go.
Okay.
So, do you prefer being called Dr. Harman or Dr. Omiti?
Mr. Omiti.
Mr. Omiti, sure.
Yes. Yes.
Sometimes I
Yeah, I know sometimes you host doctors on the show.
Yeah, when you're in the show, sometimes you forget
yeah.
or to be on the safe side, you just say Wakili. But
yeah, you just say Mr. Omiti. That's
okay.
That's perfect.
But I will give you an opportunity to introduce yourself once we do the introductions.
Yeah. That's okay.
we almost have like 2 or 3 minutes to go before we can start. We thought of changing the discussion at the last minute to look into 1 year after IEBC announced the election results. It was today.
Yeah.
Looking into what happened then.
Interesting. It's been a year, right?
It's the 15th today.
Yeah.
But then we thought it was in last minute we couldn't do.
Okay.
What's that? Good evening and many thanks indeed for tuning in to Law Matters, a show that is entertaining, informative, and offers legal aid solutions to what we face on our day-to-day lives. Tonight, we're looking into the issue of international law. How has it been applied in Kenya before and after the promulgation of the 2010 Constitution? What are some of the strides that have been made, the treaties that have been signed, and whether they have been binding here in the country? Remember, you can send in your feedback, your questions on our social media platforms at KUTV Kenya on Facebook, at KUTV_Kenya on Twitter, and KUTV Kenya on YouTube. My name is Irene Mwangi, but before we get into the nitty-gritty of this particular discussion, let me allow my guest to introduce himself kindly.
Thank you, Irene, for having me. My name is Herman Omiti, an advocate of the High Court of Kenya and a partner in the law firm of Ngeri Omiti and Bush Advocates, also known as NOB Advocates LLP, here in Nairobi. I'm very glad to be here today and to engage in this topic of discussion for today.
All right, thank you for making time. Now, looking into the issue of international law and with the avoidance of sounding cliche, what is international law? Because it is a term that has been used every now and then, but really getting the perspective of what it really means.
Yeah. International law simply means a body of rules, rules and principles that govern relationships between states, their interactions, be it diplomatic interactions, be it in terms of environment, be it in terms of human rights. So generally, there are those principles and rules that have been laid down by states that states decide by their own volition to be part of and give their authority, that they would be bound by those rules and principles.
Okay.
Yes.
Is the law a one-fit-all in terms of all, the states in the continent are bound by this one rule? Or does it change given the dynamics of different states, say the African continent, the European continent? How does it border?
There are no one-fit-all laws in that respect. In international law is varied. So we have international law at the international level, where we have the United Nations Charter, where states are members of the United Nations. Now, under the United Nations, there are various laws that states come up with from time to time. these laws they come up with because of certain necessities. For instance, when there are issues of global warming, they come up with certain laws to deal with the environment. If there are issues to do with genocide and international war crimes and all that, they come up with certain laws to deal with those. And so the laws created at different times. Within the African continent, we have the African Union, which has different laws that govern the interactions within the African continent, and cascading it down even to the East African community, where we have East African community laws that govern the relationships of these countries within the East African community. So there are laws at different levels, and of course these laws are enacted at different times depending on the needs of the states, what they need to address. They come up with certain laws to ensure that these issues are taken care of.
All right. Now, away from the broad perspective in terms of the convention that bring about the international law, what is the legal framework for the implementation of, these particular laws here in the country?
Kenya is a member of the international community, and the international community, as we've said, operate within a certain legal framework, and so Kenya fits within that framework. But of course, there's a question of sovereignty of states, and so each state then accepts to be bound by these laws, and they choose which ones they accept to be bound by. And so Kenya, as a sovereign state, also has its own rules that gives it the authority and gives the government the authority to ratify certain laws that apply to us. So in Kenya, before the 2010 constitution, these laws were applicable under the general rules of ratification of treaties, and then they would apply here. But there was a shift when the 2010 constitution was promulgated, where we enacted Article 2, Article 2, Sub-Article 5 and 6, which then specified that treaties that are ratified by Kenya become part of our laws, and that the general principles of international law are also directly applicable in Kenya. Changed the landscape a bit, but not so much, because there have been criticisms about even the draftsmanship of those two articles, because international law was still applicable, but then now we have to make reference to the constitution. So those are the broad perspectives in terms of the framework within which international law applies in Kenya. But the fundamental rule is for treaties and conventions, for them to apply here, they have to be ratified.
Okay.
Yes.
Now, which brings the question about the judicial implementation of some of these laws or even cases.
Yeah.
Because we know that our judicial system, from the magistrate court all the way to the apex court, that is the Supreme Court, when it comes to adjudication or implementation of some of these laws, are they done within the context of our judicial system, or do we have cases of a special court to hear some of these issues, especially when it borders, say, the East African community or the African continent? Yeah.
The judiciary generally also operates within a framework of laws, and the judiciary has the mandate to apply the laws that are enforced in Kenya. And so in terms of application of these laws, when it comes to the application and interpretation of international law, there has been a movement since before the 2010 constitution and after. So in terms of application and interpretation of international law in Kenya, before the constitution 2010, the courts held the view that yes, international law would be part of our laws, but with very specific, within very specific confines. In Kenya, the sources of law are found in Section 3 of what we call the Judicature Act, which defines the sources of law in Kenya, the constitution, legislation, and all that. In that definition, the international law was not part of it.
Okay.
And so because of that, the courts had taken the view that international law could only apply in Kenya under very specific circumstances. In fact, they would only borrow interpretation from international law where there was either a gap in our legal system or for purposes of interpretation where there was need, especially in human rights cases. But this moved when the 2010 Constitution was enacted, that brought international law straight into our legal system.
Okay.
Now that created a debate as to now the place of international law, because the Constitution, whereas it says it forms part, it doesn't say in the hierarchy where does it fall. Obviously the Constitution is specific that it's the supreme law, so it doesn't come before the Constitution. But after the Constitution, where we have legislation, where does international law fall? Is it after the statutes? Is it before? Or do they apply at the same level with our statutes? And that's a debate that is still out there because the courts have decided differently on that issue. While in certain cases, the courts have said that in international law is up there, and to an extent where we've had case law where the court in 2010 cited certain provisions of international law, and because of that indicated that certain provisions of our local statute was unconstitutional simply because it was not in tandem with international law.
Okay.
But then other judges came after and they had completely different views, and they took the view that international law would only be applicable to the extent that it agrees with the statutes, and so they say that they apply at the same level. So there are different approaches that the courts have given the interpretation, and particularly that issue of the place of international law within the Kenyan legal system. But at the end of the day, the most important thing is that international law is used lightly, especially in human rights cases, for the courts to borrow inspiration and make determination on human rights cases in a way that ensures that these rights are enjoyed and they're not curtailed.
All right. Given what you said in terms of giving it a perspective on the approaches that have been done previously, especially after the promulgation of the 2010 Constitution, perhaps how can you gauge the application of international law, given that there has been some sort of a clash between which law is actually supreme? Does it mean then that the application has interfered with some of the treaties that we have signed, to the extent that, yes, we have signed to be bound by these treaties, but when it comes to application, then that's where we drift apart?
Yes and no. In terms of international law and ratification of international law and how it operates, the ratification is guided or governed by Vienna Convention. And this convention determines the procedure of ratification and the obligations of states when they ratify these treaties and conventions. The one fundamental principle in international law is called facta sunt servanda, where it says that states, when they ratify treaties and conventions, they do so with the intention to be bound by those treaties and conventions and to implement them in good faith. And so whenever a state ratifies a treaty, the intention is that they will be bound, and the intention is that they will implement them. Further, the states given the obligation to ensure that they come up with internal mechanisms to ensure that they can actually implement international treaties and conventions. But of course, the understanding is that states are sovereign, and so how a state implements it differs differs from the other. A state chooses how they want to implement international law within their jurisdiction. The question of courts and their place in the implementation of international law is very key, and how the courts perceive international law affects the end result of that implementation process. So that where the courts feel that international law is simply part of inspiration, in that it's not binding, then it becomes problematic when they use it, when parties approach the court and your main argument is based on an international instrument. But it's different when the courts understand that these international instruments are actually part of our laws, and the same way we are implementing. And so I think so far our courts have implemented international law well. They have enforced international law, and particularly when it comes to human rights issues, I think we are on the right course.
All right. Now, looking at the scenario that sometimes we might find a situation whereby international law treaties will sometimes, conflict with our local laws, that is our constitution. It gives us an impression that even in other states they might have such scenarios. In a situation whereby two states are having a clash, and now the law to run to is the international law, but then the international law that is being cited in this case sort of clashes with the legal laws in their respective countries. How does that work out, or is it sorted from the onset of creating, formulating and drafting these particular laws?
When it comes to issues of conflict of laws, be it our own local legislation and international law, the rules that are applicable are different, in the sense that application of law within Kenya, if we have a certain legislation and an international instrument and the two seem not to be in tandem, then that presents a bit of a difficult scenario, as the courts have found themselves in. The Constitution is supreme, so there can't be a question or argument about any international instrument conflicting, because obviously it would not be enforced. But when it comes to statutes, courts have had a problem where they are faced with a scenario where one statute says something and the international instrument says another. For example, and that has been, since the promulgation of the Constitution, has been a problem. The civil procedure rules allows a judgment data to enforce their decree by committing the judgment creditor by committing a judgment debtor to civil jail for 6 months as a way of enforcement. There is an international instrument called ICCPR. This is a convention on civil and political rights. It prohibits enforcement of debt by imprisonment. And so a question as to whether we should enforce the Civil Procedure Act, or we are supposed to enforce this international instrument, has been in court, and it's not yet settled, because the courts have had divergent views on whether we should enforce this international human rights law, or we should go with our local legislation, which allows judgment creditors to take a judgment debtor to civil jail. And that remains unsettled because we have different decisions from the High Court. And so when it comes to application locally, it's a bit murky at the moment. But then when it comes to the international application, where two states are having a conflict, and so a state feels that their conflict is not, they are not able to resolve it at their level, then being members of the international community, they have avenues through which they can pursue those conflicts.
Okay.
So, for instance, the United Nations Charter gives the states a platform within which they can settle their conflicts. So when you look at Article 93.1 of the United Nations Charter, it specifies that all member states, by dint of being member states, are actually members of the International Court of Justice statute, which the statute creates International Court of Justice that is supposed to settle disputes between states. So the states then have a place to run to where two states feel that their conflict is not, they cannot resolve it at their level, then they can run to the ICJ, file a case so that their conflict can be settled at that level.
Right.
So they still have that option. Once a state is taken to the ICJ, they can't simply say that our laws don't allow us. They're members of the international community. And so it would be in bad faith to ratify an international instrument. Then when you have a conflict with a neighbor, you want to rely on your own local legislation to say that you cannot be taken to the ICJ. That would be in complete bad faith. That the Vienna Convention on the Law of Treaties, frowns upon.
All right.
Yes.
So what are some of the treaties and sanctions that we have signed into as a country, which now forms part of international law that governs us? And has it moved to make our state, better as a nation, or has it moved to? Some have said that some of these treaties that we get into sort of fix us as a state and as a continent, due to the different interests that our neighboring countries and continents have.
We've had various arguments and discussions around the question of what influence the international community has on us locally, and particularly on the question of morals and those kind of issues. And at the point of discussions before the promulgation of the Constitution, actually just before the referendum, different people took very different standpoints on the direct applicability of international law in Kenya, and they were of the view that this will introduce all these other things that we don't want, the vices, LGBTQ issues that have been here with us for some time. But then when we drafted that particular clause, it was not left open per se. There are still arguments around that, but we said once we ratify. So as a state, we have the leeway to choose which one we ratify. We look at our own setup, and we look at which convention or treaty is going to be useful to us, which one we can implement within our own social setup, within our own environment. And so we only move to ratify a treaty or a convention that will work in our favor. So we can't simply say that the ratification of treaties opens us up to every other thing that comes with the international community. I think the fact that we have the freedom and the free will as a state to ratify those that we choose to gives us that benefit of ensuring that whatever we ratify is something that would be beneficial to us. And so far, I think the trend has been that we've actually been very picky in terms of the treaties that we ratify. We've ratified quite a number of them, mostly in the area of human rights, and a number of statutes that we've ratified. Of course, we are members of the United Nations, so the United Nations Charter is one of them. We are members of the African Union, so definitely the African Charter on Human and People's Rights. We are members of the East African Community. So those are really the constitutive treaties and conventions that we've ratified. Under them, there are then a number of other conventions that come up at different times, and so we've also very selectively ratified a number of them along the way. There are quite a number. We may not be able to go through all of them, but I think we've been pretty selective in terms of ratification.
All right, thank you, Akili, for that perspective. But we have to take our first break before we get back to look at the practicability of international law. We had Azimio Principal Martha Karua move to EACJ to present the petition on the presidential election of 2022. We'll be having that discussion. Do stay with us. The first part was really good. Now, yeah, it's off. Sorry, it's off. So once we get back, we'll be looking into that case by Karua. Many were wondering, okay, so will the decision that they make, if any, we are not sure even how far that case went. We got distracted by demonstrations.
Yes.
So we'll be looking at that.
Yeah.
The issue of the ICJ making a ruling that favored Somalia. The president then said that they will not respect that ruling. So what happens in those particular scenarios? Is there another arbitrator that comes, to ensure that there is a sort of amicable solution in those scenarios? Then we're looking at Kabuga, and also we'll be looking at the Sudan, the former Omar al-Bashir. I'd forgotten the name. I wanted actually to give him. So before we even get into that, in the case of Omar al-Bashir, if Kenya was to be found culpable for hosting a wanted criminal, what are usually some of the charges that come into place? Are the charges sort of binding? As a nation, do we have to face the sanctions, or can we choose to ignore and say, you know what, we are a sovereign state and there's nothing you can do to us? That Bashir was a guest who we felt well pleased to host. So yes. To go. Welcome back. You're watching Law Matters. In case you're just tuning in, tonight we're looking into the issue of international law, its jurisdiction and implementation here in the country, and the progress that we have done so far after the promulgation of the 2010 Constitution. Now, Wakili, looking into the issue of implementation, now that you've given the discussion a perspective in terms of the progress that we have made so far, we had a recent case after the 2022 general election. The Supreme Court pronounced itself to declare President William Ruto as the president-elect after a presidential petition was presented in court. And then we had the Azimio principal, Martha Karua, threatened to move to the East Africa Criminal Justice Court to seek a different opinion concerning the decision that the 7-judge bench made concerning that presidential petition. In that particular case, you have not seen progress in that case. You're not sure whether the petition was really presented, how far it is, but the much that we know is that she made the intention. What happens when a petitioner takes a case to that particular court, yet within our jurisdiction, the Supreme Court is the apex and the most superior court?
Thank you, Irene. We have our own judicial system, which ranges from the tribunals, the magistrate court, high court, all the way to the Supreme Court. And the Supreme Court is the apex court, as you rightly stated. That means that any person who has a grievance, they can only go as far as the Supreme Court within the country. The issue you're making reference to is on election petitions, and specifically presidential election petitions. Again, the Constitution specifically gives the jurisdiction to handle a presidential election petition to the Supreme Court. So it means that anyone aggrieved can only go to the Supreme Court, and the decision of the Supreme Court is final. But then we understand that we have been members of the East African Community, and within the East African Community we have the East African Court of Justice, which also deals with certain specific issues that it has been given the mandate to deal with. Obviously, one of them is not a presidential election petition, but it deals with a myriad of issues, conflicts that come from the member states, part of them being human rights violation issues. And so the Azimio principle could have felt that there are certain rights were not properly addressed by the Supreme Court at that point. So they may feel that they want to draft a petition and file it at the East African Court of Justice. It would not be an election petition because the East African Court of Justice cannot make a determination on a presidential election in Kenya. It's not one of those areas that it would, but it can make a determination on certain rights that a party says that, yes, I went to the Supreme Court, but I did not receive justice because the court did not consider 1 or 2 or 3, and therefore in the process certain rights were violated. And so they want the East African Court of Justice to render its decision on those issues. And whether or not the court should do that, the court also has its own powers to determine whether it has jurisdiction in the first place to even deal with the issues presented before it. But even if you were to go past that and the court takes those issues and determines them, there is also now the question of applicability or whether the decision can be enforced. Remember, during the BBI debacle, the case went all the way to the Supreme Court, and Honorable Martha Karua still felt that it was not just. They didn't give a just determination. And other parties who decided that they wanted to now take the matter to the East African Court of Justice. So a party would have the right to go to the East African Court of Justice, but the issues there must be confined to what that court can deal with. And once that court deals with the issues, the question of implementation or enforcement back at home is a completely different question altogether. And that is largely part of the challenges of international law.
Okay.
You can go to the African Court on Human Rights, Human and People's Rights. You get a decision, but then once you have that decision, to have it implemented here, because you squarely depend on the state to be able to enforce whatever you come back with. When you go there and your claim is that your rights have been violated by the same state, then it becomes very difficult for you to eventually get that decision implemented. Worse still, if the state feels that the international law ranks somewhere lower in the hierarchy of its own laws. So those are really some of the challenges that you come across.
So what is usually then the end game of some of the citizens in the country who present a case to the East African Court of Justice or any other court? Because we also had the same scenario with the former Nairobi Governor Mike Sonko, who felt aggrieved by the Supreme Court's decision to decide that he is unfit to hold office. And then, the first thought for them is we will run, to the EACJ. But again, there are challenges and loopholes in terms of how it can be implemented. Does it mean then it is in vain for us having that particular court, given that the implementation of the decisions they make cannot really apply given the interest of any particular country?
Not necessarily. If we put it that way, then it would mean that we would discourage people from seeking justice wherever they can find it. It is important that we encourage people to exhaust all remedies that they can find to be able to feel that justice has been served. The challenge has been that in the few cases we have cited, it comes out almost as if the filing of these cases at the East African Court of Justice is like an appeal against the decision of the Supreme Court, which is not the case, or should not be the case, because the East African Court of Justice cannot handle appeals from the Supreme Court. But parties have a right to approach the international courts when they feel that certain rights have been violated, or if they feel that the state is not doing certain things that it should do. It has the obligation under the treaty or convention or international law to do. And these are matters that such international courts should be able to adjudicate on, make certain declarations and direct states to rectify those issues and to do certain things that they may not have done. And so parties should be free. The only thing is that it has to be done within the confines of certain laid down principles, so that when you want to approach an international court like the EACJ, or you want to go to the African Court on Human and People's Rights, there are certain things that you must satisfy. For instance, you must satisfy that you have exhausted all the local remedies. So you have to confirm that indeed these remedies were available. You've tried your best and you have not yet succeeded because the system has not allowed you to ventilate your case locally. Then you can approach the international or the regional court. But where you have gone through the court system as it's provided for, you've gone all the way to the apex court, and the court has considered your issues but has arrived at a decision that you do not agree with. That in itself does not necessarily give you the right to go to the next court or to the international court. But on the question of enforcement, the issue ordinarily would be that a lot of times these courts would give certain declaratory orders. So you go and claim that certain rights have been violated. The EACJ or the International Regional Court is supposed to make a declaration as to whether your rights have actually been violated and whether they can make directions that you be compensated. Now, at the point of the corrective measure is where the challenge is, because you have a decision, you rely on the state that is not willing to implement it to help you in the implementation. We're not saying that all is lost, we're just saying that it then would depend on the goodwill to be able to implement these decisions as they come, because the state also being sovereign, there's very little that the international regional court can do to force the government to, do or not do certain things. But definitely the fact that a determination has been made on that issue is a good step.
Okay. Now, we cascade the discussion further. We had the Kenya-Somalia maritime border, a case that was presented in the International Court of Justice, the UN court, which then ICJ ruled in favor of Somalia, and the retired President Uhuru Kenyatta at the time said that the ruling, they will not respect the ruling by that particular court. So what happens given that we have signed treaties and charters, to ensure that we follow a certain procedure?
Thank you. The boundary dispute between Kenya and Somalia had been quite a volatile kind of scenario, and at some point then the Somali government decided that as being members of the international community, we have an avenue. We take the case to the International Court of Justice as they should, because the ICJ statute gives them, being states, the right to do so. And so they filed the case, Kenya being the respondent. Kenya filed an objection, objecting to the jurisdiction of the ICJ to determine the matter. And the ICJ has jurisdiction to determine its own jurisdiction, and so it determined that it actually has jurisdiction, and so the matter moved forward now beyond the preliminaries to the court determining the substance. Parties filed documents in court, exchanged documents, and so it was at a point where the matter was ready for hearing. You'll recall that this was the time of COVID, and it came with a lot of challenges. And so the court, the ICJ itself had to adjust certain things to be able to accommodate the parties within that environment, and it was difficult. So the dates had been pushed, and so there was a bit of a push and pull as to whether or not the hearing could be extended at some point. And Kenya insisted that they wanted the hearing to be pushed forward, but the court insisted that the matter had been set down for hearing, and so the hearing had to proceed. And so on that basis, Kenya decided, no, we are not going to participate in the hearing anymore. We will not be party to it. But then they had already exchanged all the documents. And so what was left was oral arguments, where the parties would highlight the submissions before the court. And the court determined that now that Kenya has decided it has waived its right to appear before it and present its oral arguments, and Somalia agreed to proceed. They proceeded, and the court then considered the written documents that had been filed by both parties, and of course the oral arguments that were presented by Somalia, and rendered its decision, in which Kenya was not very happy with the outcome. So Kenya said, we will not respect. And there comes part of the challenges that we have with international law, as to whether a state can simply say, no, you have made that decision, we do not agree with it and will not implement it. Being a sovereign state, obviously, there's nothing much that you can do. But a decision has been made. In the eyes of the international community, a decision has been made that the state needs to respect. And so the understanding is that the conflict at least should have been settled at that level. Yes.
All right. With that, we'll have to take our second break, but we'll be back with much, much more. Do stay with us. So time has moved really fast. Mention about the challenges in terms of implementation. We will go back to the issue of Somalia, Kenya maritime border dispute. Now that Kenya said they will not respect that particular decision, in case we are having a strife which mostly turns into a war, especially when borders are involved, then what happens? Which arbitrator comes to take charge, given that a ruling was made and one of the parties decided, no, it is not for me? Implementation, is it an issue of goodwill in terms of the states agreeing, to exist as an international community, to the extent that the rulings that are made or decisions made in some of these courts are binding, and then now finally we'll have the far that we have to go.
Yeah.
I don't want to get into the Russia-Ukraine issue because it's a topic on its own.
Yeah,
But in such states, thank you for staying with us. You're watching Law Matters in our final segment on this particular show, looking into the issue of international law and the issue of the jurisprudence here in the country. I beg your pardon. Be sure to send your feedback on this particular discussion at KUTV Kenya on Facebook, at KUTV_Kenya on Twitter, and KUTV Kenya on YouTube. Now, Advocate Omiti, looking into what we discussed before we went on our short break on what is happening on Kenya-Somalia maritime dispute, given that Kenya has decided we're not going to be bound by this particular ruling, what happens given that the area that is in contention is rich with minerals and oil? So both countries will want to get into that, but a decision has been made. In terms of having war or a tussle, now who is the arbitrator that comes in, given that one of the arbitrators, the decision they made, we don't feel comfortable with it?
Thank you. At the beginning, we should say that when parties sign contracts, I mean the treaties and conventions, the understanding at the international level is that they have made a declaration that they are willing and ready to be bound by them, and that they will apply them in good faith. And so that goes to the entire spectrum of international law, which also includes decisions that come from the organs of international law, the ICJ being one of them. And so when a dispute is taken before the ICJ considers the dispute and renders a decision on it. It's upon the parties to accept the decision and to implement. Of course, that does not stop one party who feels disgruntled to say, we're not in agreement with this decision, and so we are not going to implement it. If that happens, like Kenya has decided that they're not going to respect it, and Somalia, because they're happy with the decision, they're going to implement it. The question of goodwill of implementation of these decisions come into play. The question of sovereignty of a state and the decisions that it makes. But of course, sovereignty is like human rights. where your right ends is where another person's begins, and so you can't claim sovereignty to the extent that it affects another sovereign state. And so Kenya might not be happy with the decision, but when it comes to implementation on the ground, they are bound by that decision. And so if at all the issue continues, then there might be interventions by other organs like the United Nations Security Council to make certain decisions if it becomes a security volatile situation that would go beyond affecting even just the two parties to maybe other state parties that are not part of this whole debacle. Yeah, and so yes, Kenya is bound by it. Whether or not they would respect it is a different question altogether. But states get into these arrangements with the intention to be bound and with the intention to implement them in good faith.
All right.
Yes.
Now, what happens in the scenarios that international law conflicts with culture mostly, or the Constitution of Kenya? And now I will cite the issue in Uganda in terms of the issue of the dicey issue of the LGBTQ rights.
Yeah.
And we saw the IMF come into that discussion in what appeared to be the International Bank compelling Uganda to be bound by certain human rights. Where do we find ourselves being placed in? I know the country have not gotten to that particular discussion, but now how do we balance culture and international law and ensure we exist as a community?
Culture is normally a very emotive concept because it's personal, and they are as different as the humanity itself, and so we cannot force our culture on a different group. But the international law operates in an environment where we refer to as civilized societies. So civilized societies then operate in an environment where certain cultures might be deemed as being repugnant to what we call justice and morality. And we're saying that if you want to insist on a certain cultural standpoint, which in the totality of it doesn't look like it can operate in a civilized society, then it's important that you reconsider that position because you operate within this body called international community. But when it comes to implementation of international law, as we said before, countries decide which international law to ratify and how they want to implement it locally. And so if Uganda decides that, look, for us, we can only go to this extent when it comes to LGBTQ issues. It's a very dicey issue, but it's a decision that they have made as a sovereign state, and that decision ought to be respected because from their own viewpoint, they have not outlawed LGBTQ. They're outlawing certain issues, and whether or not it's a good thing is a completely different conversation. But I think the World Bank coming in to issue sanctions on the basis of that alone is a bit stretched. But of course, we live in a society where we should not be too restrictive. To the extent that there are certain segments of the society who cannot be allowed to live their lives.
Now, as we bring the discussion to a close, due to being pressed on time, what are some of the recommendations that you would say should be put in place to ensure that we, yes, exist as an international community by signing some of these treaties and some of these charters, but then again, we ensure that the independence of the existence of a sovereign state is maintained, because some of the times this conflict when it comes to the independence of a state when they get into signing some of these treaties?
states are never forced to ratify treaties and conventions. It's free will, it's a choice. In ratification, there are certain treaties that they can even partially ratify.
Okay.
And so there should not be a notion where we're saying that a state has been boxed into a corner of ratifying certain treaties and conventions. But the moment they have ratified them, then they should not also be had to be complaining that this is now not allowing us to exist freely, because before a state ratifies an international instrument, they are assumed to have understood the full effect and impact of that particular instrument on itself as a state and on its people, and they are supposed to do so to improve the relationship between itself and other states, and of course domestically they're supposed to also improve its own people, so that when it deals with human rights issues, then the understanding is that they will enhance the environment where human rights can be easily enjoyed by their people. So states cannot say that we have been boxed, we are put in this situation where there's nothing we can do because we ratified a certain treaty or convention. There are also instances where a state can decide that we are no longer interested in being part of that treaty, and they can walk out. The process is a completely different ballgame altogether to finally be out of that particular instrument. But they always have certain clause that allows